importance of labor and employment laws cannot be overemphasized. While it is important for employers to maintain a positive work environment and also to reduce the legal risk. Similarly, it is important for employees to understand the basics of the labor and employment laws, to protect themselves from discrimination at the hands of employer, unfair treatment, and also from any kind of harassment. India's legal landscape with respect to labor laws has undergone a change when the government, in fact, brought the four labor codes, because labor and employment is a subject matter in the concurrent list, and therefore both the central and states have the power to make laws, and therefore plethora of laws were present in labor and employment matters. So the government had shown a willpower and codified the laws into four codes. Now, my colleagues Pranshu and Tejaswini both are senior associate in the firm, and they will talk about the changes that have been brought about by these labor codes in little more detail. Over to you, Pranshu.
Before we proceed with the entire presentation, just allow me to give a brief insight as to why this topic of employment laws in India holds relevant at this point of time, especially in 2025. So, I would just like to begin with quoting one of India's visionary industrialists, Shri J.R.D. Tata, and I quote: "The effective execution of a plan is what actually matters, and not mere planning on paper." Now, having said that, compliance with employment laws in India has to go beyond the policies, and it has to be reflected in actions and employees' experiences both. The strength of any organization does not lie only in the infra or the ambitious project they plan to adhere to and comply with. However, it lies with the people who are actually driving the change, that is the workforce. And that's where employment laws comes into picture. It plays a very key, crucial role in ensuring an equilibrium and balance between both the interest of the organization and the rights of the workers. So ultimately, it aims to cater to and flourish and achieve the nation building objective, build on three main platforms, that is social justice, stable workforce, and economic growth. Allow me to take you all through the very brief insights into labor legislations that are actually prevailing. Later on, my colleague Ms. Tejaswini will be taking you through the reforms that are there in Indian legislations. So may we move to the next slide. What is labor and employment law? In a very brief nutshell, we can say it actually meditates all aspects of relationship that arises between the trade unions, the employees, and the employers. And hence, we can say that it is a body of law, administrative ruling, precedents that are addressing the legal rights and restrictions on working people and their organization. Broadly, it covers the industrial relation, workplace health safety standards, and again the employment standards. We will be discussing that in detail at a later stage: holidays, leaves, hours, dismissal, etc. Now, moving on to the next slide. What is the need of these labor legislation in Indian landscape? So the innovation, the economic growth calls for regular change given the dynamic nature of the labor force in India. Hence, few pointers that we have actually jotted down through the presentation. It facilitates productive relationship, again, between all the three concerned players, the union, employers, and the employee. Then it guarantees fundamental rights. Now, rights and directive principles are there largely available in public platform and constitution. However, not every employer is well, and also the employee is not well aware of the defined system of law. Hence, it establishes a process to implement and enforce workplace principles and rights, and ultimately it achieves the harmonious relation, and it provides for a framework for both the employer and the worker interaction. Now, just moving on to the next slide, I'll just give you a brief intro into this. So, as already pointed out by Mr. Anil Tiwari, that the subject area of labor falls under the concurrent list under the Constitution. So, all the subsequent legislations that we are going to discuss at a later stage, that actually emanates from this constitutional framework. One is the fundamental rights, right to equality, freedom, life, personal liberty, right against exploitation. The other is the DPSP, the Directive Principle of State Policies. They are not enforceable. However, they guide the state governments and the union government while implementing and laying out the legislation. Now, just allow me to run you through the key industrial laws that are actually prevalent in India. Industrial Disputes Act, it governs the dispute working condition. It has laid down a very specific inclusive definition of workman industry. If I can just give a small example, like the definition of industry has undergone a series of change through different precedents. So any relief material initiative, distribution of relief material initiative taken by a government will not amount to an industry work. It has to be habitual and systematic production and distribution of such materials. So this has been actually clarified through series of precedents. Again, we have Shops and Establishment Act. It is again amended as per the state laws, because again, the state and the union both have the power to legislate and administer the labor sector. Then we have the Factories Act of 1948. It ensures safety, health, and welfare of factory workers. Then we have the Contract Labor Act. It regulates contract labor employment and protect the rights. Now, the next slide. So through the next two slides, we have actually mentioned the legislations across broader subheads like financial security laws. So we have given a very brief insight into few of the labor codes also. It will be dealt in detail by my colleague, Ms. Tejaswini. However, I'll just run you through the larger bracket they fall under. Financial security laws, it includes Payment of Gratuity Act. It mandates gratuity for 5+ years of service. The maximum limit amount is also there. Then it is calculated at 15 days wages per year. Then we have the Employees Provident Fund Act. It establishes the EPF, the Provident Fund, the EPS, the pension scheme, and the deposit scheme, the EDLIS scheme for financial security of the employers, of the employees. It also applies to the establishment where 20+ workers are there. Now, Payment of Bonus Act, again, it requires annual bonus for establishment with 20+ employees, and it is also based on the profit and productivity of that particular organization. Now, moving on to the next slide. This slide mentions about equality and social security. Again, the three acts that falls under this bracket: Equal Remuneration Act. This ensures that equal pay is given for both men and women for the same amount of work. Then we have the Maternity Benefit Act. It provides maternity benefit, including wages and leave up to 26 weeks. Then we have a Code on Social Security. This again, code will be dealt in detail later. We have just made a mention because it falls under the social security aspect. This code has consolidated the laws on social security benefit, and it also ensures that a comprehensive protection is given to all the workers employed. Now, let's dwell into a bit interactive mode here. We have just placed a small questionnaire here to just test the participants' general knowledge, maybe we can say. I would request all the participants to just give their response through the chat box, and we'll wait for a minute here. So a food delivery app refuses to register its riders under any social security scheme, stating that they're not employees. So under the Code on Social Security, is this position legally tenable? What is your view? Just any one of the options, if you may please provide your response with. I would request the participants to please contribute in this interactive session. Okay, so we have a response B. No gig workers must be covered under notified schemes. Okay. Right. Let's move on to the next slide. It answers our query here. Yes, so as rightly pointed out, under the Code on Social Security 2020, the Indian legislature specifically recognized the gig workers. It will not come under the conventional definition of employees. However, they are entitled to the Social Security benefits under specially notified scheme, again by the central and the state as per the state legislations. Now, next move on to the next slide, please. Yeah. So the key takeaway from these labor legislations, whatever we have discussed in a brief, basic pay is always 50% of the gross payout. That payment is fixed irrespective of the deduction and allowances that is provided. Then the fixed term employment. The employment terms and conditions has to be clearly laid down, well communicated to both the employees and the employer. Then compulsory appointment and offer letter has to be provided. Then the gig, the platform, and the unorganized workers are now well recognized under the labor codes. And then the leave provisions. Again, it has to be very clearly laid down and communicated to the employees. I'll continue with this slide now. So yeah, this slide we have jotted down and bifurcated the kinds of employment that is in regular terminology is generally used by the organizations. So we have permanent, contractual, interns, and then we have the consultants. So the permanent ones, they're actually hired directly by the organization and they are on a fixed term basis, strictly governed by their employment terms and conditions. And it's a long-term strategic role there. Hence, they are entitled to all the benefits that arises from there, the PF, the gratuity, the bonus, the leave, and etc. Now, the contractual employees, again, they are there for a fixed term. The freelancers can also be considered under this, and they will be governed by the Contract Labor Act and the Industrial Code again. So this may include the PF and the ECI. However, the benefits are very limited compared to the permanent employees and strictly governed by the contractual terms. Again, they are hired for the skill specific roles. Then we have the interns. Interns are basically unpaid. Generally, the larger motive is learning and exposure. Then we have few interns that are hired for stipend. Those stipend, if they are done as per the state allowing the intern stipend and the duration of the employment, then they may come under few of the minimum wages applicable rates. So, however, largely it is a temporary engagement. Now, the last we have the consultants. So, they are the professionals and they are mainly hired for advisory expert services. Hence, statutory benefits are not given to them. However, their employment terms again governed by Indian Contract Act. Again, it makes a very rough mention of the fee consideration, the acceptance and offer. However, few non-compete clause, non-disclosure clause and IPR related clauses are also generally incorporated in those slides. Now, just I'll run you through these corporate specific regulation given the presentation is specific for Densu. So again, codes on wages, equal pay, minimum wages, timely payment of employee has to be adhered to. This again will be dealt by my colleague later on. Then code on social security. It again covers, it's a culmination of all the social security legislation that we have already discussed. So PF, ECI, gratuity, maternity. Then Shops and Establishment Act, it regulates the working hour. 9 hours per day, 48 hours in a week, and it applies to our commercial establishment. And obviously, as per the state as per the state government, it's amended from time to time. Now let's move on to the next slide. Yeah, so corporate specific regulation. The second part is POSH Act, the Prevention of Sexual Harassment Act. Again, the Internal Complaints Committee is mandatory to be complied with. It also applies to workplace where 10 plus employees are working. Now, the IT Act of 2000, it also applies to the organization and it regulates the cyber conduct, data privacy issue, and it is very critical for especially the remote working environment and the hybrid mode of working that we engage in. Let's have another set of questions for the participants here. So yeah, this is quite a easy one. We have just made a mention of this. So what is the minimum number of employees a workplace must have to mandatory required to set up an internal complaints committee, ICC, as per the POSH Act? I may request the participants to please enter their response in the chat box. B, 10. So, right, we just had made a mention. So, any organization where 10 plus employees are there, it's mandatory to have a ICC committee. Now, let's move on to employment contracts and compliances. Now, again, we have made a very general mention of what all compliances are required when you are dealing with contractual terms relating to employees. So, appointment letter, HR documentation, it has to specify the role, salary, probation period, terms of service, and all the employment records has to be updated. Non-compete confidentiality clause, it ensures that protection of sensitive business data and client information is ensured. Then regular audits has to be done, conducting HR and legal audit at subsequent period of time, and identifying any compliance gap that is there. Now, wage compliance, we have to ensure that timely payment is done and adherence to the minimum wages act has to be done. Let's move on to the next slide. So the culmination of all these points that we have discussed is jotted down in the next few slides. So the key compliance area which a organization has to roughly look into: employment contract offer letter, as we have already discussed, defined clear terms of employment has to be there. Termination clauses should be well defined. Non-compete terms should be well defined, well communicated to the other party. Any state specific shop and establishment act, any updated amendment, any circular has to be complied with. Then we have the wages and benefit, adherence to minimum wage act, again timely payment as per the payment wage act, and ensure that all the applicable EPF, ESI, gratuity, bonus act are also complied with. Now moving on to the next slide again. Working conditions and safety, again, the Factories Act governs it. However, the new code on occupational safety, health, and working condition also governs it, maintaining a safe workplace, hygienic. Then leave and holiday entitlement, again, all statutory holidays has to be complied with. Casual, sick, earned leave as per the law has to be complied with and provided and well communicated to the employees. Then sexual harassment compliance, in compliance with the POSH Act, it is mandatory to have ICC, as already discussed. Regular training and awareness training and sensitizing the employee is also important, and it's mandates. Now moving on to the next slide. Statutory registrations and records. Again, maintain a register, file returns, even if a company is inactive for the last 1 year, file the nil returns, ensure timely renewals, filing under applicable state law, any amendment, any circular notification calling for compliances has to be adhered to. Termination, retrenchment. Now, follow due process under the ID Act, the Industrial Relation Codes again. It's the very recent code. It's still there in implementation phase. Then comply with the notice period, any severance payment, and employee communication. Now move on to the next slide. So apart from all these compliances, there are very common, largely discussed area of common pitfalls. I'll just run you through these that the organization has to take care while dealing with employees, workers, trade unions. So generic vague employment contract term has to be avoided. It actually leads to disputes and enforceability issues arises at a very later stage. Then miscalculating of wages, variable pay reductions that are not aligned with the legislation, it has to be looked into. The non-formation of ICC is actually a very serious non-compliance under the POSH Act, and it invites heavy penalties. Then we have failure to update the policies, then ignoring regional and state legislations that is being amended from time to time, that has to be looked into. Then improper termination, we have a lack of documentation, then overlooking compliance during the mergers and acquisition. This has to be kept in mind that the employee rights and liabilities also transfers and changes with any change, organizational change. So compliance has to be adhered to. Then poor record keeping, non-filing of returns, and lack of grievance redressal framework. So these are few of the common pitfalls that organization has to look into to ensure that the compliance of employment laws are well adhered to. Then again, engaging any apprentice, any trainees, again, it is a direct intern engagement is questionable. However, state specific notified engagements are well within the legislations. There are few certified schemes for apprenticeship training, for apprenticeship program that are allowed. However, degree holders cannot be categorized as intern and apprentice, and that has to be looked into so that it does not violate any of the legislations. Now, I would just take you through of the interactive questions again before my colleague takes it forward. So, which one is not a mandatory compliance for private employers under employment laws? I will request the participants again to please give your response as per your understanding. Okay, so now let's move on to the next slide to have the answer for this. allowing indefinite unpaid internships. So Indian labor law, they do not permit indefinite unpaid internship under any, unless it is structured or specified by the state government or the union government scheme. Like there is a NETA scheme, that is a National Apprenticeship Training Scheme. And indefinite unpaid internship, especially if it is an intern performing regular work, same as the employment terms, it violates the minimum wages law and hence it is not allowed. Now let's move on to the next question. Next slide. So a tech company is engaging a fresh engineering graduate as intern for 6 months. However, that intern is doing a very full-time coding work without any stipend and not enrolled under any government scheme, such applications. So is it a valid apprenticeship under Indian law? What is your understanding? I will again request the participants to give their response, please. Okay, so we have not got any response yet. Okay, no problem. Let's move on to the next slide to have the answer. Yeah. So, no, unless it's a governance certified scheme, as I already mentioned, it will be covered under the employment laws. So it has to be a government certified scheme, and the compliance with the government certified scheme is actually required. Apart from that, the interns can be engaged. Now, I would request Ms. Tejaswini to take it forward, please.
Good afternoon, everyone. I am Tejaswini. Thank you, Pranshu, for giving us a comprehensive and detailed background of what exactly are labor laws, the need for labor legislation, and a detailed explanation of what industrial laws and financial security laws that govern our country at this point. We have also covered major takeaways from the labor codes, corporate specific regulations, and how various clauses of employment contracts and its non-compliance may hamper the growth of not only the company, but also the employers and the workmen. So I will basically take everybody through the current labor reforms. And India has now taken up all of the labor codes that they have, and they've consolidated it into 4. And if we can go on to the next slide. Yes, why we needed this reform. Now, if we may understand the brand new code and why it was required. We have already noted that from the earlier slides that labor is governed by the concurrent list, meaning thereby both the parliament and the state governments can enact laws on it and modify it according to the nerve of the workforce in their respective states. However, the central government acknowledged the need to bring about a transformation in the labor codes, as there were about 40 central laws and more than about 100 state laws on labor and its related matters. Can we go to the next slide, please? In order to properly adapt to the economic and social challenges of the modern world, it was noticed by the Indian government that the labor codes need to include and facilitate for the ease of compliance, balance of the welfare of the employees, and the ease of doing business in India. Reduction in complexity. Now, various codes had various definitions of wages, workmen, etc. So, in order to reduce this complexity arising of the various definitions and interpretations of the same term under existing labor regulations, we required the labor reform. Thereafter, a new concept of Shram Suvidha has been introduced, which and guarantees the fundamental principles and rights at work, which have received broad social acceptance and establishes the processes through which the principles and rights can be implemented and enforced. The four codes that consolidate the previous laws have already been enacted in 2019, but the states had been given a deadline up to 31st of March 2025, which of course has been surpassed. Now coming to this slide is fine. So there are basically 4 labor laws that have been introduced. The Code on Wages 2019, Industrial Relations Code 20, Health and Working Conditions Code. These reforms seek to facilitate ease of compliance by striking a balance between the welfare of the employees and provide some relaxation in doing business in India. Next slide. So basically, they consolidate all of these codes. If you maybe be able to go through, there are several codes that have been consolidated and I would say have been absorbed into these 4 separate codes. Next slide, please. Now, the key provisions that differentiate the older laws and the newer laws have been spread across the 4 labor codes. Now, because of the archaic and the complex legalese that was used in the earlier codes, the reform also seeks to reduce the complexity arising out of the definitions. Now, as I've already mentioned, various examples of how there was an overlap of definitions in various codes were in the Payment of Wages Act, the Employees State Insurance Act, the Minimum Wages Act, and the Labor Codes of 2020. There is a stark difference of how wages is defined. The Payment of Wages Act, wages broadly include all sums payable under the conditions of employment, including amounts due in accordance with awards and settlements, overtime compensation, and amounts payable due to termination of employment. But the new Labor Code of 2020 defines wage as a broader term, wherein it includes all remuneration payable to an employee in cash, whether for work done or for any period of leave. This also includes allowances, reimbursements, and other benefits. Can we go on to the next slide, please? Now, wages may include basic things like basic pay, dearness allowance, retaining allowance, but it will not include bonuses, house and allowance, PF, overtime allowance, etc. Now, as I had already mentioned, regarding the Shram Suvidha registration, what the legislation now intends to do is that we have a common license and registration. So one registration requirement has been introduced by the labor laws, and the registration needs to be done through a Shram Suvidha portal. It must also be noted that all old establishments will have to update their information regarding all of their workmen, employees, etc. on this portal as and when the law is ratified within a period of 6 months. Factory, the definition of factory has also changed. It earlier increased. So now it has increased from 10 to 20 workers with the aid of power and 20 to 40 workers without the aid of power. Working hours has also been changed. It has now been reduced to 8 hours. Earlier, it was 9 hours plus 1.5 hours as break. Now it has been reduced to 8 hours, and there is no segregation between the working hours of an adult, an adolescent, or a child work. Overtime payment has also been defined now. It would be the twice of the normal rate of the wages. Inspector, this is a core concept that has been introduced in the new labor laws. Inspector cum facilitator. The concept of inspector and facilitator has been introduced now. This is basically not to just carry out search and seizures, inspection of the records, but also act as a facilitator by rendering advice and guidance to the employers and employees in relation of compliance under the code. So in the sense that they basically act as mediators between, say, probably the trade unions and the employers, so that they can strike a balance between the two and the animosity is kind of decreased. In case of that, also been now defined. Fixed term employment means the engagement of an employee on the basis of a written contract of the employment for a fixed period. The hours of work, wages, allowance, and other benefits shall remain the same for a permanent employee. In an offense committed by a company, then every employee who at the time of commission of the offense company will be deemed guilty for the same. Okay, now we can come to a fresh question. Kavya is hired on a 1-year fixed term contract as a design consultant. She completes her term and is relieved. and then she claims gratuity. Her employer denies it, citing 5-year rule. Is Kavya entitled to gratuity under the new labor code or not? I would invite everybody to give their responses. A. Unfortunately, the answer as per the new labor code is as per section 53 of the code on Social Security 2020. It grants a gratuity eligibility to fixed term employees even if they have not completed 5 years of continuous service. And now to conclude, Indian employment laws have always had a archaic notion to it, but now considering with adapting times, with how we've interacted with the world, how our equation is with various countries, and how we are now in head-on competition with various countries, it was seen important by our government to bring on these laws, and they've brought in some welcome changes to it. And this is very, very pertinent for the corporate sector as well as the non-corporate sector, the industrial sector, for a fair, safe, and productive environment, and for understanding from recruitment to termination based on the engagement type, the workforce, how one needs to tackle the workforce, and how to maintain business continuity, and how to strike a balance between the reputation of the company and the workman. And